Greetings to one and all. You're listening to MMJC Fortnightly podcast. In this month of May, all certain such companies to whom dematerialization of securities is mandatory will have to file Form PAS-6. Till date, this Form PAS-6 was to be filed by unlisted public companies only. But from now on, such private companies who are not small companies also would be required to do so. So, in this edition of MMJC Fortnightly podcast, we shall be discussing about applicability of Form PAS-6 to private companies. And to guide us in this regard, we have with us Mr. Akshay Shah from MMJC. So, Akshay, let's start with first things first. First, tell me, what is this Form PAS-6? I mean, what is it about and when is it filed?
So, Form PAS-6 is a half-yearly return for reconciliation of issued capital of a company vis-à-vis the shares held in dematerialized mode, in CDSL or NSDL or held in physical form. Since it is a half-yearly return, it has to be filed within 60 days from the end of each half year. That means for the half year ended 31st March 2024, the form has to be filed up to May 30, 38, 2024. And for the half year ended September 2024, the form should be filed up to 29th November 2024.
Okay. Now, I am aware that unlisted public companies are required to file this form by the virtue of Subrule 8 of Rule 9A of Companies Prospectus and Allotment of Securities Rules 2014. But how does this form become applicable to private companies?
As we are all aware, by inserting Rule 9B to Companies Prospectus and Allotment of Securities Rule with effect from 27th October 2023, MCA has mandated the private companies to dematerialize their securities. Subrule 5 of this newly inserted Rule 9B says that Subrules 4 to 10 of Rule 9A related to unlisted public companies shall apply to private companies as well. Therefore, Subrule 8 of Rule 9A that talks about filing of Form PAS-6 shall also be applicable to private companies.
Okay. But Rule 9B talks about dematerialization of securities by all private companies who are not small companies. So does this mean that all private companies who are not small companies will be required to file Form PAS-6?
Subrule 2 of Rule 9B gives time to private companies which are not small companies as on the last day of financial year ended on or after 31st March 2023 or thereafter to comply with this rule within 18 months of closure of such financial year. So, private companies which are not small companies as on 31st March 2023 are required to comply with this rule on or before 30th September 2024. However, Subrule 5 of Rule 9B, which is the originator of the requirement of PAS-6, does not mention any time period. Hence, it is ambiguous whether PAS-6 filing requirement will get triggered from the half year ended on 31st March 2024 or from the half year ended on 30 September 2024. Further, if we analyze the Rule 9B, then broadly speaking, the only obligation cast on the company by Rule 9B is facilitating demat of securities. That is, getting connectivity with either NSDL or CDSL by obtaining International Securities Identification Number. Thereafter, it is the obligation of the securities holder to get the securities dematerialized. All other obligations on the company arise only if it is issuing securities or buying back its securities. So, if a private company has already obtained ISIN, then it can be said that the company have already complied with Rule 9B, even before the time allowed under Subrule 2. In such case, there is no reason why such a private company should not file PAS-6 for the half year ended on 31st March 2024.
Right. Even as per Subrule 1 of Rule 9B, if fresh issue of securities is made in the time period prescribed in Subrule 2, that is, from the date of notification of Rule 9B till 30th September 2024, then such fresh issue has to be made in dematerialized form only. Therefore, many companies must have already registered themselves with depositories and obtained ISIN. So, such companies have already complied with Rule 9B. And even if there is no fresh issue of securities is proposed, it is still recommended that companies should obtain ISIN before 30th September 24. So tell me one thing, if there is one company who is still in the process of obtaining ISIN, then is such company required to file Form PAS-6?
Actually, if we refer to contents of Form PAS-6, the ISIN is a mandatory field. Hence, if a company does not have ISIN, then it will not be able to file PAS-6. If a company has got ISIN after 31st March 2024, then also it can file PAS-6 for the half year ended on 31st March 2024. But this form cannot be filed until and unless ISIN is obtained.
Okay. And what if a company has obtained ISIN, but all its security holders have not dematerialized the securities? Then in such case, can the company file Form PAS-6?
Yes, definitely. If such a company has obtained ISIN, then it can file the Form PAS-6 by stating that all the securities of the company are held in physical form.
Okay. And is there any fees for filing this Form PAS-6? And does it require any certification from professionals?
Yes, there are filing fees on this form which are based on authorized capital slabs. And if the form is not filed by 38 May 2024, then additional filing fees shall also be payable. It also required certification from practicing company secretary or charter accountant. Further, this form is on V3 portal of MCA. So we need to take care of V3 portal requirements also while filing this form.
Okay. Thank you, Akshay, for such elaborate discussion. I am sure this discussion would have clarified all the doubts regarding filing of Form PAS-6, particularly with respect to private companies. For the benefit of the listeners, we shall insert all the rules discussed in this podcast in the description of the podcast. Thank you for listening to us. Please feel free to reach to us at mmjcinfo@mmjc.in.